mutation entry, and auction certificate are not substitute for clear chain of title. So modern practice often relies on certified photocopies, which I would not advise because we actually need to see original documents. If sale deed is registered, stamp duty is paid, and the seller is in possession, would we assume the title is clear? Most of us would. And the assumption is where most of the property dispute begins. Because registration record transaction, it does not guarantee ownership. Mutation shows the name, it does not create title. Possession indicate control, it does not establish ownership. Every property carries a legal history, and sometimes that history includes undisclosed mortgage, heir who never consented, restrictive covenant, limiting development, a defective power of attorney, a pending litigation. On paper, everything may appear perfect, but one defective link, 30 years old, can collapse the entire transaction. Title verification is not about checking documents, it's about investigating history. It's about identifying hidden risks within the property documents and records before they become expensive dispute. So today we will examine how to detect those risks through structured legal investigation. Title is only as good as the title investigation behind it. Title verification is not a procedural checkbox. It is a foundation of every property transaction. So when title is defective, consequences are severe, like litigation for decades, bank enforcement under SURFACE, delay in project, loss of property investment. So when we conduct title investigation, we examine whether document disclose proper ownership, whether there are gaps in a chain, whether statutory restriction applies, whether encumbrances exist, whether seller has the competencies to transfer. Let's take an example. If property is inherited and one legal heir has not signed the conveyance, the defect may remain silent for years. But that heir can later file a partition suit or challenge the sale. So title verification prevents this. It converts assumption into legal certainty. Let's take few definitions. Title. What is title? Title means the means whereby person's right to property is established. It is not mere possession. It is not legally recognized ownership enforceable in a court. Title deeds. What are the title deeds? They are documents containing or constituting evidence of a title to land or a property. So they are protected as the primary documenting evidence under section 135 of Bharatiya Sakshya Adhyan 2023. So original title deeds are really critical. If original are lost, what we must do? We must file FIR, we must issue public notice, or indemnity should be taken, because title rests upon a documentary continuity. Without documentary evidence, ownership becomes vulnerable. Now let's go to immovable property. So immovable property is defined differently under different statutes. Under General Clauses Act, it includes land, benefit arising out of land, things attached to earth. Under Transfer of Property Act, it excludes standing timber, growing crops, or a grass. Under Registration Act, it includes building, right of way, light, ferries, fishery, and any other benefit arising out of land. So the key principle here I want to mention is definition varies by statute. And why we need to refer all these definitions? Why it is important to do so? Because classification determines transferability, stamp duty, registration requirement, development restriction. Let's take an example. Right of way. Right of way is an immovable property. If access road is disputed or unrecorded, buyer's enjoyment of property may be compromised. Therefore, identifying the governing statute is really important. Now let's go to title deeds. Title deeds can be of different nature. It can be sale, gift deed, release deed, partition deed, lease deed, transfer pursuant to probate or letter of administration. Each type of deed create ownership differently. For example, sale deed create absolute transfer for consideration. Gift it. Gift it is a voluntary transfer without consideration. Release it. Relinquishment of a share. Partition deed, what does it say? Division among the co-owners. Lease deed provide for limited right for specific term. Probate transfer, it is a succession-based ownership. So let's take an example here. If property is leasehold, transfer may require prior permission from lessor. So it's really necessary to look into the document whether permission of lessor is required or not. Therefore, mode of purchase or acquisition determines scope of investigation. We need to see which documents we are referring to, and accordingly investigation may vary. Now next we see why we must investigate title. This is a fundamental question I would want to cover here. So first, registration does not give ownership. Registration does not guarantee valid title. Sub-registrar verifies just a procedure compliance. It does not validate the title. Then mutation entry. Mutation entry does not create title. Revenue records like 712 property card may shows the name that are incorrect due to fraud or incomplete succession. There may be hidden encumbrances which are not apparent on a face of the document. There may be missing documents. There may be forged documents. In private sales, auction sales, property often transfer as a as-is, where-is basis. So investigation is really necessary here because onus is on buyer to check the title of the property. There may be Benabi transactions. So only thorough investigations expose this risk. Now let's go to legal doctrine on which fundamental investigation of title relies on, and that is caveat emptor. Caveat emptor means let the buyer be aware. So auction sale or a private transaction, onus is on the buyer to see whether proper title is there. So to see the title of seller, buyer must do proper due diligence. Buyer assume the risk of undisclosed defect. Entire burden of due diligence lies on buyer only. With the enactment of FRERA or a consumer protection law, now onus of caveat emptor shift to caveat venditor. That means seller must be aware. Means seller must disclose all the legal lacuna or title defects. Under transfer of property, it is duty of seller to disclose all material defects. Therefore, independent title investigations remain indispensable. Let's go to benefit of title investigation. So why we conduct investigation of title? There are benefits. Here, buyer protect themselves because as I mentioned, onus is on buyer to do proper due diligence. He has to take the property with proper due diligence. So he has to protect himself. So when you investigate the title, he protects himself. Secondly, there may be prevention of litigation. If you know in beforehand, then there is a litigation, then obviously you will be aware of it. Then you come to know there are restrictive covenants in a document. So by going through the documents, you come to know about that covenant. There may be hidden defects which is unknown to even to seller. I mean, seller may not be aware of there are defects in a title which is coming from the original seller. So title investigations transfer uncertainty into legal clarity. So let's run through some recent Supreme Court judgments which are passed in 2025, recently, last year only. In one of the Supreme Court judgment, that is Mangur Fatima versus State of Telangana, Supreme Court has held that unregistered sale agreement cannot confer ownership. Subsequent registration does not cure defective title if the seller did not hold valid title at the time of transfer. So, mere registration does not clear your defective title. Then there is another judgment, K. Gopi versus sub-registrar and others. Here, court has clarified that the sub-registrar's duty is purely administrative. He cannot adjudicate the title. Registration records the execution and not the ownership validity. So sub-registrar does not go into validity of a document. He has to see whether document is executed, whether stamp duty is paid. So he doesn't go deep into the title of a document. So here, what is the takeaway? Registration does not validate defective title. Then there is another judgment where Supreme Court has held that mutation does not create or extinguish the title. Ownership does not follow mutation. Then one more judgment, State of Punjab versus Alloy Forging Private Limited, where it is held by Supreme Court that auction sales certificate is valid proof of ownership. However, it is evidentiary in nature and does not replace investigation of previous encumbrances. So what is the takeaway here? Mutation entry and auction certificate are not substitute for clear chain of title. So what are the legal framework we need to look into? Understanding relevant statutory framework is an essential for thorough title investigation. We must understand that property transactions are never governed by one single law. They insert multiple statutes simultaneously. For example, Transfer of Property Act that governs transfer of ownership right. Indian Succession Act, Maharashtra Stamp Act that governs stamp duty compliance, Registration Act that governs registration requirement. Power of Attorney Act becomes relevant where transactions are executed through agent. RERA Act regulates real estate development project. MOFA comes into picture when flat purchaser comes in a picture. Maharashtra Apartment Ownership Act applies to apartment structure. Then there's a Maharashtra Cooperative Society Act for governing housing society. Then there's a Maharashtra Tenancy Agriculture Land Act that governs agriculture land transfer. Then there's a Maharashtra Land Revenue Code which governs the land classification and revenue record. Then there's a Maharashtra Public Trust Act which applies to trust property. And then obviously we need to consider Income Tax Act, GST Act that may create statutory dues impacting the title. Personal succession law determine inheritance. So we need to consider Indian Succession Act, Hindu Succession Act, as the case may require. So property transaction must therefore be examined within the correct statutory ecosystem. We cannot say that only transfer of property will do the needful. No, we need to look into different statutory provisions. Failure to identify the governing statute can invalidate the transaction. So advocate or solicitor who is doing due diligence on behalf of buyer must look into all the relevant provisions available in different statutes. Now let's go to the fundamental thing. What are the steps of due diligence? Though there are broadly 6 steps we need to cover to check the title validity. We need to obtain title deeds. We need to examine chain of documents in that. We verify whether the statutory compliance are done while going through the documents. Then comes the steps of issuing public notice. Then we do check for encumbrances or conduct search. We'll go in detail of each steps. And then ultimately, advocate or solicitor issues a title certificate in respect of property, whether document is clear, title is clear or marketable or not. So this sequence must be followed thoroughly. It converts documentation into legal clarity. These are fundamental steps which one must cover to check whether the title is clear or not. Now let's go in detail with each step. So first, as I said, obtain original title documents, which is very necessary to see whether seller has a valid title or not. So, traditionally in Mumbai, buyer's advocate were receiving original title documents against accountable receipt. So accountable receipt has to be executed, and undertaking, it is kind of undertaking where buyer will say that we will return the document without claiming a lien in the property. Here, buyer's advocate's duty will be to preserve document carefully, and they will not part with the documents before the completion and return the document as per the undertaking given by them. Now, why we should take original documents? Because original documents confirms authenticity, stamping, execution, and registration details. If original documents are not available, obviously we must advise that FIR must be lodged, public notice must be issued, indemnity must be obtained. But original inspection significantly reduce the risk on title. So it's always advisable to look into original documents. So one step is we execute accountable receipt and obtain original title deeds from the seller. If that is not possible, we have alternative mode. What we can do is we can visit seller's advocate office and take an inspection. If property is mortgage, we can visit seller's bank and inspect the document. So modern practice often relies on certified photocopies, which I would not advise because we actually need to see original documents. So for high value transaction, original verification remain strongly recommended because photocopies cannot reveal alteration, overwriting, or physical tampering. Now, when we are going through the document, what we must examine? We need to see the root of title. Root of title means how old title we need to check. So there is no specific provision for that, but reasonable timeline is 30 years. We need to see the root of a title for at least 30 years. Now, why I say 30 years? Because when property is obviously old more than 30 years. Why I would recommend that? Because under Indian Limitation Act, certain limitation for certain filing of suits are 30 years, like for redemption of mortgage, foreclosure. So limitation period for filing such suits are 30 years. So to take precautions, we should at least conduct search for 30 years. Let's go to what kind of property we are buying and see what document we must see. Like for example, if it is flat in cooperative housing society, what we must see? We must see agreement for sale, deed of transfer, index 2, share certificate, NOC from the society, occupation certificate, property card. If it is an apartment under Maharashtra Apartment Ownership Act, we must see declaration, deed of apartment. We need to see whether they are registered. Then there's a floor plan, then car parking details, obviously, then utility bills, tax receipt. And if it is plot of land, then we must see, obviously, a title document agreement for sale. Then if it is a lease deed, then lease document, then 712 extract, property registered card, if there are DP remarks, Kami Jastapatra, 612, assessment bill. So each different type of property requires different scrutiny. Here, while running through the documents, when we have already taken a possession of a document to check the title, what need to see? So material flex, we need to see whether it is a grant, if it is a property taken, it's a government property, or if it's a freehold land or a leasehold land. There's a litigation. So if there's a litigation history, there's a right of way, easement. If it is mortgage, if it is coming, the title is coming through wills or a succession, then there's a death in a family, if there are restricted covenant in the document, then legal part, obviously, whether it is stamped or registered. It requires summarizing the legal journey of property. We need to look into each document, whether all, whatever is there, and we need to make a list of the events. So material facts we have discussed. Now, what legal compliance we need to look into? So one is whether proper stamp duty is paid. If it is in Maharashtra, Maharashtra Stamp Act must be taken into consideration. Gujarat, then Gujarat Stamp Act. Then whether registration is done or not. Sometimes sales are through power of attorney. So we need to see whether power of attorney is properly authenticated or registered. If principal was alive and document was executed, because power of attorney gets revoked if principal giving a power has died. Then if it is a property under MLRC, whether permission has been taken. If it is agricultural land, then whether land is given to agricultural land is given to agriculturist only. So we need to see all the, so each case require different scrutiny. If it is not complied with, then it transfer becomes vulnerable. It can be challenged. So we have gone through the documents. We have seen material facts, what we need to see, legal compliance part we have covered. So after running through the documents, next step will be we need to issue public notice. Now public notice will be of 14 days. It is issued to the public inviting claim that safeguards against third party claim. Now what will be the duration of this notice? 14 days. How many newspaper advertisement is required? So ideally two newspaper. One will be in English and one will be vernacular language where you are residing. So if claim doesn't come in 14 days, so it strengthens the title for buyer. So it strengthens the position of buyer, that though public notice does not cure defect, but it reduces the risk exposure. Now public notice is gone. Meanwhile, what we will do? We will check the encumbrances. We will see the sub-registrar office. As I mentioned, we need to do 30 years search. We can appoint a search clerk. He will conduct search report. He will do search and give us a search report. He will do 30 years ka search, or how many years property is there. If it is 10-year old, then obviously we will do 10 years ka search. This will give us whether in a document, whether any document is registered in respect of this property. Then there is a surface search. Means if any loan or mortgage is done, then if it is registered. So surface search helps us help in detecting the mortgages and charges registered in respect of that particular property. Then litigation search. We need to see records of high court, city, everything is now online. We can check that records also, whether any litigation is pending. If there's a list pendency registered, then whether insolvency proceeding is filed. So encumbrance search is protect purchaser from hidden liability, which is not apparent on a document. So running through this search will give us some clarity whether any document are registered which is not reflecting in your document. Or there is a litigation, obviously sale deed does not provide for litigation, that there is a litigation respect of this property. So individual must do all this search to have a clarity on a title. Then obviously if seller is a company, so these are additional steps we need to take. If seller is a company, we need to do MCA search. We need to see the ROC records. If it is partnership, then obviously we will see registrar of firm and do our research search there. If it is trust property, we need to see whether charity commissioner's property permission is done or not. If it is collector's land, then we have to see whether 37A of Maharashtra Land Revenue Code is complied with or not. If it is agricultural land, then we need to see whether Section 63 provision is complied or not. So each ownership structure requires specific verification. Then we talk about taxes and lease verification. So in Maharashtra, obviously there's a government land, collector land. There are restriction on leasehold land. So we must run through the lease deed, whether there are restrictive covenant, whether we need to take a permission of lessor, we need to pay premium. So each document will speak for itself, and we will come to know whether what next step we need to take. Then when we talk about taxes, so property tax has a first charge on a property. We need to see whether in a pending dues check last bill where all payment is done. So there is no pending dues. Now, after running through the search report, after public notice is done, what we can do is we have obviously prepared our list, what queries as a buyer has or advocate of buyer has. Then what buyer can do is they issue requisition on title. So buyer has right to raise the questions. Requisition can be of special and general requisition. Special requisition will be directly in respect of title of seller, like whether seller has a title or not, if it is inherited property, whether property is taken or not. And general requisition will be general question, whether there is a charge, whether there is a mortgage. So if we do not have any clarity while running through the document, we prepare our requisitions or a query as a buyer's advocate, and we will raise the requisition on seller. And it is duty of seller to answer this requisition. So seller must answer relevant question under Section 55 of Transfer of Property Act. So after raising a requisition, after obtaining an answer from the seller's advocate, there will be defects which can be cured, there will be defects which cannot be cured. So let's take few examples. If documents are missing, if there's a clerical error, there is a remedy available, though it's not 100% satisfactory. But if buyer is very much interested in a property, what he would do, he will ask for indemnity, he will ask for FIR to be lodged, he will ask for a rectification. If it is a clerical mistake, then ask for rectification deed or a confirmation deed. What is incurable defect? What I would say that buyer should not buy those property if the document are unregistered. wherein registration were compulsory. If under Section 17 of Registration Act, certain documents are required to be compulsory registered. And if those documents are not registered, then buyer should not go ahead with the transaction. If there is an adverse order from the court, then obviously that transaction should be avoided. Obviously, then ultimately it's buyer's call. If it is commercial, it is commercial call. But as an advocate or as an advisor, as a solicitor of a buyer, we should advise that we should not pursue with these transactions. Then let's go to special consideration for specific sellers. There will seller can be individual, company, seller. So what extra precautions we need to do when sellers are, if it is partnership firm, we must see in the document that all the partners has executed document or not. If it is public trust, we must verify trust deed and resolution if permission from charity commissioner is taken or not. If seller is private trust, we must verify trustee's power. I would advise that a beneficiary should also execute as a precautions. If the seller is company, then we need to see board resolution, memorandum, and articles. We should review those documents also, and whether insolvency proceeding is filed against company or not. So, checking of title of company, we obviously, as I mentioned, we need to see ROC records to see whether there is any mortgage or a charge in respect of property of a company. If seller is HUF, we must see that Karta and co-partner have executed the document. And if minor in the family is there, then we must obtain court permission. And one must consider that nominee as, sometimes person has died and there's a nominee. So Cooperative Society Act, so whether nominee is the owner. So nominee is not the owner of the flat, he or she does not become owner of the property. He is a trustee for the benefit of legal heirs. So in that scenario, not nominee, but legal heir must execute, or if there is a will, probate should be obtained. It is advisable to, obviously there is a recent amendment where it says that now probate is not compulsory in Mumbai, Calcutta and Madras also, but it is advisable to obtain probate. Then certain transaction is executed by attorney, through power of attorney. So in that situation, what we must verify? We must see that whether principal who has given the power of attorney has the ownership in respect of the property, whether that power of attorney, if it is required to be registered, if it is for the sale, if it is registered or authenticated before the sub-registrar, whether it is specific, we must see the power of attorney, whether it has special power to sell the property. If power of attorney holder is NRI, then we must see that it is notarized before Indian consulate, properly authenticated or not. In this situation also, we must issue public notice as a way of extra precautions. Because when transaction is through power of attorney, there are chances of fraud. So we must be extra careful in that situation. Then comes a title certificate. So as an advocate or solicitor of a buyer, or in whichever situation, advocate or solicitor issues title certificate, where he will say, or he or she will say whether property or a title to the property is clear and marketable. Now, what is clear title? Clear means property free from encumbrances. Now, what is marketable title? Marketable title means it is free from reasonable doubt. So title certificate is generally required if there's a development project under MOFA, RERA project, loan transactions, or you want to be sure that property is clear and marketable. So as in by way of extra precautions, we take title certificate from the attorneys. Title certificate must actually state that there's a defect in a title. So it should be transparent document. Transparency is a mandatory. So as a lawyer, we need to be careful and we need to mention whether there's a defect in a title or not. So when we talk about title certificate, as I mentioned, title should be clear and marketable. Now, what is marketable title? So there are few characteristics I have pointed out here, that there's a clear ownership, it should be free from encumbrances, it is in conformity with the law, there's a continuation chain, There's no litigation, and there's an undisturbed possession. If reasonable doubt exists, title is not marketable. So these are broad characteristics I have mentioned that what is marketable title. Though it is not exhaustive list. This is a Bombay High Court judgment, Ramnik Lal Tulsidas Kotak versus Varsha Builder, where Honorable High Court has mentioned that what should be disclosed in a title certificate. So Bombay High Court has mandated that title certificate must disclose nature of title, encumbrances, steps required to make title marketable, whether title is doubtful, whether authorization is irrevocable. Non-disclosure of all this expose advocate to professional liability. So it is duty of an advocate or a solicitor as a professional to see whether everything is complied with. So I have pointed out some advocate's duty which one must follow while making a title certificate. What they should do, they should pursue all deed thoroughly, conduct necessary searches, issue public notice, raise requisitions, obtain declaration on oath, exercise independent judgment. So here I would say title certificate is a professional responsibility, not a clerical formality. So I have briefly explained how we should go about title investigation. I would like to conclude here by saying that title investigation is not merely a formality, it is a critical safeguard. Despite statutory protection, the onus remains on the purchaser. Professional solicitor must maintain the highest standard of diligence and disclosure. Only a clear and marketable title provides true scrutiny in property transaction. Transaction may close in a day, but defective title can result in litigation which may last for a decades. That is why title verification remain indispensable.
Yeah, madam, I am staying in New Panvel. My
Hmm.
building is 28 years old, and while taking purchasing from the builder, my brother has taken a title from the advocate. But after 28 years, we found our building is illegal. Our printout of what you call blueprint is of 11 flat, and we are staying here with 30 flats in the building. We are having the advocate's title report also. But now Sidco is saying you are having only 11 units, and whereas this building is 30, and they say that it is illegal.
So that's what when so while going through, have you checked the title certificate or have you checked the records which were available at that time? What were permissions required? So this is where we get a problem that while purchasing the property, we don't go into the detail. Now it's been 20 years. Now there will be limitation issue. There will be tell me one thing. If you can elaborate your questions, is there any notice for a demolition or something?
No, 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 no. What we are going for the redevelopment, and there are 11 flat has not been transferred so far from Sidco. So 11 people were there. So they have gone to the Sidco. Sidco said, no, it is your illegal building. And there is a remark of the officer. It is saying only 11 units should be there. And our OC and all CC, it's showing 11 units. In the OC, it is blank.
OC is blank.
Blank. It doesn't give any unit number. CC is having 11 unit, and blueprint is of only 11 units. And there were something 4 copies were with the Sidco, but 1 copy which all the calculations were there. They say it is a misplaced. We have done RTI and everything, but that copy we are unable to get it. Now we are going for the redevelopment. Now we are having a problem.
So, person who has constructed the building, do we have any connect with them?
No, now it is 28 years. He has become old and he is bankrupt now. And all are having the title reports from the advocate, all 30 flats.
Because title report will be only it obviously there's a lacuna or a problem with title certificate only because advocate has not done his proper due diligence.
Now we are suffering now.
That's a whole game.
Because they are saying the blueprint is not matching with our
Title
building.
certificates provide for all this. That
Yes, all 30 people have from different advocates we are having.
so for each unit you have title certificate, or you have title certificate from builder?
No, no, no. From each flat we have taken a title report.
No, no. Then that title report will be in respect of that particular flat only.
Flat only, yes. All
So,
30 people have done that.
so which are unauthorized flats,
Yeah.
that title report says what? It must be annexed with some supporting documents, permissions and all.
No, all these orders, no, all these search reports are saying it is title is clear. But now it has opened. Now it has come to our
We
notice
need
that
to see the document, because without looking into the documents, I can't really answer your query. But title certificate, one is which builder takes in respect of land, that it's a Sidco land, and permission
yeah,
allowed till this many floors, and for that this is clear and marketable. But if you are talking about respective particular flat, then
yeah.
you need to see whether from which angle of relying on which document he has mentioned that it is clear and title marketable title in respect of that flat. That has to be challenged. Then
Now
he must be advocate must be relying on something. So this question requires actually scrutiny of your documents. Without looking into it, I really can't advise, because it's 25 years old and I don't know what title certificate talks about.
Yeah, ma'am. This is regarding a society where the conveyance is obtained and one of the chain documents is missing. Can it be substituted by any document for putting the name into the property card?
So what documents are missing? Substituted means if it's old documents, if person is not alive, like suppose A has transferred to B, B has transferred to C. Now you are saying C is a person who is alive, but chain of events A is not there. So how you will you
Yeah.
substitute? What is
A sold
can
to
you
A sold,
clarify?
yeah,
Can
yeah.
you be little?
Yeah, sure. A sold to B, B sold to C. C entered into a partnership deed along
Hmm,
with the immovable property with the partners who developed the property. So
hmm.
that partnership deed is what the property card was asking about, insisting upon, which is missing in the index too. But the conveyance is favoring the property.
So now to enter into property revenue record, they require this document, which is missing. In that situation, because conveyance is already there, you can always request them, okay, we can give indemnity. Indemnity will suffice, or we can um, lodge FIR. For missing documents, what we can do is we can file a FIR, we can do obtain indemnity, and we can submit with the department that this compliance part we are doing, and kindly issue the kindly change the record.
Oh, that typically should suffice.
That should be suffice, because main
Okay,
document conveyance is already there. Then they
that's
should
right.
actually they should actually transfer on basis of that conveyance only. You are saying after partnership date conveyance is already done.
That's right. That's right.
So
That's
main
right.
document conveyance is already done, and conveyance must provide for the chain of events that it has entered into partnership, and then partnership has acquired this. It must recital must disclose that. I mean, I hope it is providing.
Yeah, the status include disclose that, except that particular chain document is missing.
Huh.
Okay.
So
Okay.
for that chain of documents, you can always go for indemnity. You can provide, you can request, you can give affidavit or undertaking by way of indemnity, and then it should be fine.
Okay. Madam, one short question.
Hmm.
The search clerks, these are official by the registrars or they are private parties?
They are actually private.
So can that be
They are,
reliable?
they are authorized. They are authorized. So they are authorized. They are allowed to check the records of sub-registrar.
And submit a search report on the basis of
But
which the
yeah,
advocate.
then it's up to you as an advocate or solicitor whether to rely on that search clerk or not. That individual thing one need to be careful about. Well, sometimes so I have also gone through the situation where one search clerk has given search report where he has mentioned that from period A to period B, all the documents are torn. From period B to C, computer records are not available. And for similar search, I have given assignment to some other search clerk, and he had given me proper detailing.
Oh, wow.
So how that person is doing his duty, that will differ.
So there's nothing like certified copies straight from the registrar.
So once you get a search report now, then
Uh-huh.
you have to run through that search report, and then you have to see whether, so what a search report will show you. It will show you chain of events, whatever
Right.
documents are registered. For
Mm-hmm.
example, you have taken search for 30 years. So
Mm-hmm.
whatever documents are registered in that 30 years will reflect in his search report. So you need to run through that document, then you can request him obtain certified copy of that particular document that he can obtain from sub registrar's office.
Yeah, but in order to actually strengthen the search report, can it be certified by the registrar that these are the
No.
no,
Search
it does
report will be in his private
in the
name.
private parties. Yeah.
Yeah, he will sign. As such, they are authorized, but he will not. It will not be certified by sub registrar's office.
So there usually is an authority letter between the registrar and the search clerk. Authorized means,
I need to check. I'm not
oh,
sure
okay.
because it's private level only.
If something is missing in the search report, then we know as to where to go or where not to go. That's why.
How diligently he has done his duty, that will depend.
Yeah, like in
Because
the case of
there are
which I
multiple examples. I have also gone through that search.
oh
Some are very good and they do a nice job, and some are like they will give you in 2 days report mentioning that nothing is there in the record.
Now, I was saying there is a big layout. In there are multiple buildings, multiple buildings, and now the recreation ground that RGs has to be put na, in the big layouts. Some 15% has to be put as RG. That he
Yeah.
has shifted RG throughout the period for last 20, 30 years. He has shifted RGs. Now this RGs has been shown in open areas of our plot. And now BMCGM is asking us to matlab, accept that RG. Ki now since you are not an individual land, you don't have a 712 extract separate. You have a 712 extract of all the lands in which everybody's name, all the society's names are written. So you are not the individual owner. That land does not belong to you. It is a layout land like that. They are saying.
So,
That
so
what matlab,
that
I'm not from a legal
layout is
background, so
approved.
I understand that much. I'm handling one of these situations.
So there is an entire layout where there will be allocation of what you said, that 15% RG will be there, and
Hmm.
so it could have been the situation. It has been approved or submitted by one developer who has then assigned it to different builders who has constructed the different buildings. For
Hmm.
example, in
Yes,
Mumbai
ma'am.
also it's a HTIL layout, and then it's sublet to different builders. So in that situation, at that time, whatever plan was submitted,
Hmm.
it has to go according to that. Then there can be a modification of a plan which must have been approved. So those documents we must see. You can ask for the inspection of a documents how that RG has shifted from this land to that land. It must have been approved.
Yeah, it was approved, but without our consent.
So then your document will definitely must have provided that builder can do whatever he wants without your approval, because that's a tendency, that is the practice which has been following since years, that builders take under MOFA agreement blanket approval, blanket consent, they can do whatever they want. You just buy your
okay.
property, whatever you get, that's it. That unfortunate
Okay.
situation is there.
So, ma'am, what can be now remedy, ma'am, for this? How
You
to remove that RP?
But then you have to file a RTI application, you see the documents, you
We
talk.
have filed. We have got all the documents. Their
Have you seen
layout has been.
that? Have you seen that RG area has been shifted and how it has been shifted
But
under?
on paper, it has been shifted to our land, our open area. It has been shifted on paper. Physically, it has not been shifted. Physically, though, we are having in possession, but on paper, in after conveyance, also it has been shifted in our plot
And it has
presently
been shifted when?
in 2004, ma'am, and our conveyance is 85.
Now we are in 26.
We came to know now, ma'am, because redevelopment.
No, but it has been submitted and approved. Practically, you can't do anything unless you fight in court, which will go on for a. It's a matter of now
Long time.
negotiation, nothing else.
So, ma'am, land.
So in MOFA, there's a provision. Now there's a RERA that builder cannot do anything or cannot modify any plan without showing it to flat buyer. But
Okay.
all are living in Mumbai. Have we seen any document which gives buyer that right? No. It's always
No.
one-sided document where builder will have all the right, and we can't do anything. We have to accept as it is. We have to pay and take possession. Taking if we get possession in time,
We should be happy.
yeah, we should be able to get that possession in time. Then you are lucky one. Forget about all modification.
We go through many title documents daily. So there are one question was put up that what in case what documents we should check if the property is in under construction. What all documents we will be able to check? if the property is under construction, how the title will, like, what we need to check?
So whatever is records available, you need to see past 30 years ka record minimum. Under
Okay.
construction means builder has taken possession, whether it is redevelopment or a development. If it is redevelopment, then obviously society has given to builder. If it is development, builder can be owner, he must have taken from landlord. If it is leasehold land or freehold land, if it is leasehold land, then you have to see the lease deed. If it is collector land or a trust properties land, as I mentioned in my presentation, seller can be anyone, and then accordingly you need to see. So you have to do search, and then whatever documents you are available as a registered document, you must see that. And under construction, whether obviously what permission is taken. If property is Mumbai, then as per whatever Maharashtra statute provides for that, we need to see that. Land revenue records, we need to see that. So your question is not specific, what documents, so whatever is available for past 30 years as a registered documents and revenue record, you examine all this. So builder who has demolished and now, or who has constructed or is constructing, whether that builder has a title to that land to construct or develop the property.
Once you have executed a release deed or a gift deed, etc., uh, what exactly is the next step or a document that will ensure clear title?
If you can specify what property, if it is a
It's a
flat,
residential flat in a cooperative housing society.
then transfer share certificate in your name. If it is gift in your favor, on basis of gift deed, take share certificate in your name. Possession obviously must be yours. If it is release deed, take share certificate. So one is registered gift deed or release deed, and I hope everything is properly registered, stamp duty is paid and done. And then what is another title document in society? It is share certificate. You have both and you have possession. You are done with it.
Thank you, ma'am. So it means that there is no need for a separate transfer deed to be registered with the registrar after these two documents have been done.
If deed transfer in your favor,
Thank you.
release deed transfers in your favor. It's a registered document transferring ownership. If it is 50%, if it is 100%, that will depend what you are getting under those documents.
And subsequently index.
You are owner. If it is 50%, you as a donor will be 50% owner and donor as a 50% owner. So it will be 50% ownership, and share certificate will be issued in both names. So
Understood.
share certificate document. Then obviously society may ask for affidavit or
Yes.
something. That compliance part will differ to society.
Yes. And then index to entry will automatically appear once the registration is done.
Yes, definitely.
Thank you so much, ma'am, for sharing your expertise. It was your first time with us. We can't thank you enough for accepting our invitation to speak and sharing your valuable insights. It was a great, enlightening webinar. Thank you so much, ma'am.